Hello. In this clip from our Justia webinar, Podcasting 101, Advising Clients in Pre-Production, Production, and Distribution, Alexia Bidet discusses the contractual and clearance issues you need to have in mind while working with podcast creators and producers. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So contractual specifics. So here I'll go back to there's a lot of words on the screen, and this is just an example of some of the things that I've mentioned before about nuances that may come up specifically in the boilerplate, which, there can be a tendency to maybe, by the time you get to the end of the boilerplate, maybe it's like thinking this, either there's not going to be the ability to negotiate it or it's not going to matter. But again, the boilerplate tends to set out who indemnifies who's repping and warranting what. And so threading the needle there and making clear that your client's repping and warranting only the things that they should be based on what their responsibilities are is super important. So, for example, if you're representing the host, there's all kinds of things that the host is going to rep and warrant. What's on the screen more is if you represent the production company, what are the reps and warranties that you may want to get from the host so that the host can enter into the agreement, that there's nothing preventing them, that they're not going to in the future grant any rights that interfere with this agreement, that everything's going to be wholly original to the host. It's not up there now, but, query whether you want the host to rep and warrant that they haven't used AI without getting your permission. That might come up. They'll typically rep and warrant. It's the fifth bullet point that the materials are not going to infringe on the production company's use of that what they deliver will not infringe on third-party rights. So that's important there, that it's not defaming anyone. So there's just a few examples of things that if you're representing the production company or the entity that's acquiring the rights, you might just be mindful of trying to include. Sorry, I lost that. There we go. Here then we talk about, so before, if you look at the slide, we had the reps and warranties that the host would make, and then there's the indemnification. So if the host breaches one of the reps and warranties and you sue the host, then what have they agreed to do? And I highlighted defend there because that's not always in there, right? Do they agree to not just hold you harmless and cover the costs that you incur, but can you require them to defend, i.e., step into your shoes, take over the defense and have to deal with that? And I think there's sometimes a bit of a knee-jerk reaction that you put defend in there because you assume that it's going to be better, but maybe you don't want the host to necessarily defend because you don't want them to take over the defense because, you want to yourself or you're going to have better counsel. So you might put defend at your election. So it's very clear that they only defend if you want them to. It's not that as a condition to indemnifying you, they have to also have the opportunity to defend it themselves. So there's all kinds of things that you may want them to defend you against. And then I put there yellow little Roman numeral 2. Do they defend and indemnify you, or at least indemnify you for things said by the people they invite on the show? Or have you added the guests to E&O insurance if we didn't talk about insurance? But that typically is also something that gets negotiated in the deals. Who's responsible for getting insurance? At what point in time? And you also, you make clear that you as the production company can compromise and decide to settle a claim at any time that you want. There's additional considerations if you're representing here the production company, or if you're representing the host, but, did the host contribute third-party materials, right? If it's about their book, is the host rep and warranting that they have all the rights they need to the book for you to make the podcast? Same with the title, right? Who came up with the title? Is it a pre-existing title? You have all the rights you could possibly need to the title. Are there prior agreements that are related to the podcast that need to be assigned to you? So lots of things to think about. And now flipping it to the other side is if you represent the host, what do you want the production company to indemnify you, right? Because if you're the host and you're, you know, writing, maybe you're not even writing the scripts, maybe the host is just really more of a the voice of the show. And if your client is really the voice of the show and doesn't have as much say into the writing, is not clear on whether things have been reviewed or not, if your client, the host, gets sued because of something that was said on the podcast and that they didn't have any control over that, it's maybe not the host. Maybe you're representing the talent in a scripted podcast, and the talent comes in, they read their lines, but they haven't written the script. They have no idea whether the script is maybe based on someone else and there's copyright infringement. So if you're, depending on the services your client is rendering, if they get dragged into a lawsuit for something they had no control over, are they being indemnified appropriately for that? So there's an example there of some language that you might have. And then the question is, the second bullet point there is, when do you agree to defend the host, right? Because if you're the production company, are you going to step into the shoes of their counsel and actually defend the claim? Or are you only agreeing to indemnify them? And you'll see often the production companies or the buyers don't necessarily want to agree to defend. And there's a ton of qualifiers that are put to when they agree even to indemnify. Again, a lot of things here. So sticking to the idea that if you represent, this goes to threading the needle, like I said before, right? So in that first bullet point, if you represent the podcaster who's delivering the project to the buyer, the production company, let's say you represent the production company here, you want to exclude from the indemnification obligation of your client who's producing it all kinds of things, right? So if you see there, it's material that's supplied by the buyer, that's excluded, right? If you get in trouble because of what the buyer told you to put into the podcast, that's excluded from your indemnification obligations. If the buyer has acted in a way that's reckless or willful, that's excluded. Like I said, you see the note there. If the financier has final cuts, then maybe if you add something that says, if you get in trouble for language that we said don't put that in, but because you had final cut, you won and you put it in, that's excluded from the scope of the things that will indemnify you. So it's, a lot of language there, and this is by no means the only way to do it, but it's just sort of things to think about as you're going through the agreement. Now, that was a lot of words, so we'll stick to clearance issues. So everything we spoke about before with how you might be brought to advise clients, and I'd say a transactional way, whereas now what's coming up is your client is producing the podcast, and you are brought on as clearance counsel to make sure that the podcast they put out there into the world is free and clear of legal claims, or at the very least, if they receive a legal claim, that they are going to be able to, get it thrown out on a motion to dismiss, or you're going to be able to write a very convincing letter, because there's never, the fact that you get it legally reviewed doesn't mean someone couldn't object. It just means that you've hopefully put the client in a position where if they do get it, there's not going to be a colorable claim that will be brought against your client. So what are the things you might be asked to review and advise on as an attorney? It's the script, potentially. It might be the audio cuts. It might be trailers. You might be reviewing promo copy, so what they're going to put on the Instagram posts. It might be the interviews themselves. I like to get involved, I think, as early as you can, the better, because if they've already gone through, recorded the script, they have the audio and have to go in and make changes to the audio based on problematic content, it's a lot more, it's more annoying for the client than you give them notes early on at the script. You go back and forth a few times, and then they just record something that they know is going to be, fine and good to go. The only qualifier to that is if they're putting third-party material in, which we'll get to in a second. Where there's third-party material, you may need to actually listen to the audio to make sure that the way that the audio comes out is a fair use as well. And we'll get to fair use in a minute. Another way that, we can be helpful as attorneys here to our clients is not just reviewing, but anticipating. So if your client is, an experienced producer, that might not be an issue, but maybe the first few podcasts they produce, you run a producer training session where you give them rules of the road for what they, can and can't say, and what's defamatory, and where do the lines about privacy stand, and what kind of, best practices for news reporting and sourcing, and what does it mean to have a source that's on the record versus off the record, and all of those things you can go through with your clients before. And this, especially where it's, what you call like an always on show, or if it's a daily show, a weekly show, where your client may just not have the budget to have every single episode reviewed by legal. So you tell them, okay, well, if you see X, Y, Z, this is when you elevate it to legal, and these are the episodes that I should review. Music comes up a lot in terms of content that's used, and it's, important if you're licensing music and not fair using, which we'll get to in a second. But the licenses, you'll need both a license if it's for a song, both the master license for the use of the recording, and then the sync license to be able to use the recording in sync with the podcast. And then this next point is quite in the weeds, but there's also, public performance rights. And then and this really comes up if you're representing a client like a production company that's delivering the content to a large platform or a network. Often the master license and the sync license won't include a buyout of the public performance rights. And so having clear in your agreement, like if you represent the production company with the platform, that typically the platform has an overall deal with the performance rights organizations, and that they will cover those fees. So sometimes you'll have the language like I had on the screen, which makes clear that the buyer is going to be responsible for, fees owed for public performance rights, which, if you don't have that and then you haven't bought them out and you said you would deliver a podcast that's fully cleared, that's where there's a disconnect. So licensing materials and fair use. This comes up all the time. When can you use third-party material without getting the license, and when should you get a license? So this comes up a lot with archival, right? Especially unscripted, both, but in unscripted shows where they're talking about, I don't know if it's a show that looks back on the music of the Rolling Stones. Are you licensing all of the music, or in some cases, are you going to be able to fair use it? And I'll turn to, fair use a bit more. The cover art, do you have all the agreements in place there? Music I just spoke about. And so if you're not licensing and I actually thought I had more slides on this. I don't, but I'll speak to it briefly because I think it's important. If you're going to fair use material, which I won't get into detail because I'm sure a lot of people listening to this are familiar, but it basically means, it's an affirmative defense under copyright law, where even though you've not gotten permission from the copyright holder, the law recognizes that you've used the material in a way that there's a general public interest that you should be able to do that. And so the law permits it. And there's a number of factors. There's unfortunately no clear way to know whether something or not is fair use, because the courts look at 4 factors. They look at, the nature of the use, the nature of the underlying recording, how much of it was used, what's the effect on the market, the fact that you haven't licensed it, is it causing them harm? And most importantly, they look at, have you transformed the use? So if the original clips are news clips that are talking about I'm trying to not come up with a sad event. So talking about the results of an election, and you're using those clips not to relay what the results were, but your podcast is actually about how the media has evolved and how different sectors of the media cover different topics, and you're using different clips to compare there, that's the use is different. The original use was to convey information, but you're using it here to comment on the different manner in which people report the news, different news organizations report the news, or music, for example, like the Rolling Stones. If you're using a part of the song Miss You and you're talking about a certain chord progression that was very unique to Mick Jagger, and then you cut to, a couple of seconds or just as long as you need of that chord projection for progression for your audience to understand what you're talking about. Are you using no more than necessary? It's for a new use, right? The original use was entertainment, listening. The use now is not for that, but it's to illustrate and be commented on, and in the context of commentary, which is different. And judges apply this analysis in a very difficult way. And it's kind of unfortunate that fair use, which is meant to benefit people, ends up actually requiring a lawyer to opine on whether something or not is fair use. But you're likely to be asked to help your clients figure that out often if they are asking you to do the legal review on their project. And if you are licensing the content, you want to, think about, it's in the same way the guest releases, how I was saying, think about the potential restrictions that you're agreeing to with the guest and how their interview can be used. It's the same thing if you're licensing material. So if you're licensing material to put in your show or your client's show, is the term in perpetuity or is it limited? Because if it's limited, it means that in a year, you're going to need to renew it. And the truth is sometimes your clients may not afford to be able to get a perpetual license. So they may have to license for a limited term. But if they do, the next best thing is to have a renewal option with a preset fee so that your client knows that every 5 years, if they got a 5-year license, they'll be able to renew at X rate. It's typically you won't get perpetual renewal options. It might be for 1 or 2, but at the very least, it gives you a bit of time. And the other thing is making sure, if you can be helpful to your client when they are licensing things that are for a limited term or for limited uses, that they're tracking that. Sometimes they'll have clearance charts and permissions grids that they'll ask you to help fill out, because when they're delivering their show to the buyer, they need to let the buyer know. So yeah, typically in a license, those are the things that'll be limited. The term, the territory, is it worldwide, which for a podcast, you want it to be worldwide. And if there's any restrictions, is it only for one use? Can you use it both in the podcast and in the trailer? Can you use it more than once in the podcast? Can you only use it in the podcast in its form? Or if your client wants to do one day an anthology of all their shows, is that a double use to have the right? So just making sure that if you are licensing content, you're tracking the terms of the licenses very clearly. ADA compliance, I put that there because it's important to be able to, you need to have the scripts that are available for your podcast. And so this can just making sure that sometimes there'll be restrictions, like the talent won't want you to have the right to have a transcript or to subtitle or something. And you just to remind them, I can't strike that language because the podcast has to be available. There has to be a transcript. And First Amendment consideration. So a lot of this is, when you're reviewing the script, it's separate from the copyright issue. Is my client going to get in trouble for what's being said in the podcast? And so defamation, privacy, news gathering, there's a little bit maybe sometimes that feeling that, oh, it's said in audio, it's said so quickly, it's okay, people aren't going to come after me. Maybe, but they do. I mean, there are definitely, you don't really see many, I don't know if there's been really any that have reached trial stage because often these things get settled. But very important to, what is said on a podcast is just as capable of being defamatory as what's written in an article or what's written in a book. So, if it's a podcast about, I don't know, a certain industry, or it's a podcast about, whether it's an entity or a person, making sure that anything that's a statement of fact that could be true or false, and that if it's false could be defamatory, What's the sourcing there? Do you have more than one source? You don't always have to have more than one source, but do you, what's the sourcing there? Have you reviewed the source? If the client had the show fact checked, and sort of understanding if you have a question and there's like the sources that are linked in the script, actually making sure that, because sometimes it just happens, right? You'll link a source thinking that, is it actually what's said in the source? For example, the complaint, if it says they were found liable, or they, committed something, but actually you open the source and what the source is a complaint, and you have to make clear that the complaint alleged that, and just making sure often that the sources that you're provided by the client actually support the way that the client has interpreted what's in the source. So sort of going that extra step is going to be very helpful for many clients. And like I said before, on the record, off the record, that's important as well, because if the source is off the record and your client gets sued and they only had one source, that source is off the record. It's as if they didn't have a source, because that source is off the record, which I don't know that people necessarily always realize. And then another thing that goes back to the guest releases, you may have guests that agree to participate on the condition of, not being named. And it's always important whenever I see in a script, so-and-so who will name X told us about, their first divorce. And then their voice is there. And so I'll always go back at the release and say, well, what exactly did you agree? Because if this person gave you an interview thinking you were going to use someone else's voice and you agreed you wouldn't identify them, not identifying someone is a very different agreement than saying you won't be named. Because obviously if you can't identify them, that probably means you can't use their voice. So being very specific about what you will and won't do with your sources and your interviewees is very important in that way.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.